Hello friends! One of the most challenging issues that divorcing parents face is school placement. What I mean by that is determining where the children will either attend school during a divorce or post-divorce. This past August, unfortunately, I had to try 3 separate school placement motions in court. These were full-blown evidentiary hearings that were stressful for the parents and the children involved, as well as for the school teachers or school officials that were subpoenaed to testify. Not to mention, very expensive. Today, we are going to dive into why school placement is such a challenging and major issue during divorce cases. Welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. All right, so why is school placement such a major issue in divorce cases? And I'm sure many of you already know this answer. School has such a huge impact on a minor child's future. The school that a child attends influences their education, influences their social circle, their extracurricular activity, opportunities, and their long-term success. So both parents may have strong opinions about what is best for the children, and this may be the source of disagreement in terms of school placement. Additionally, there may be some conflict between the statutory language and the party's parenting plan or custody agreement. What do I mean by this? Well, let me give an example from the state of Florida. In the state of Florida, shared parental responsibility is defined by Florida Statute 61.046. Now I'm going to read that statute briefly. Everybody hang in there with me. I'm also going to provide a link to Florida Statute 61.046 in the description of this video. But according to that statute, shared parental responsibility means a court-ordered relationship in which both parents retain full parental rights and responsibilities with respect to their children, and in which both parents confer with each other so that the major decisions affecting the welfare of the children will be determined jointly. So if the parties have shared parental responsibility in their parenting plan, they must make all joint major decisions, which includes school placement, together. But this language of shared parental responsibility may conflict a little bit with some of the statutory language that is required in parenting plans in the state of Florida. Parenting plans are governed by Florida Statute 61.13, and there's a section that tells you what absolutely has to be in parenting plans, and one of the requirements is that a parenting plan approved by the court must at a minimum do the following: designate who will be responsible for school-related matters, including the address to be used for school boundary determination and registration. So this makes it a little bit complicated, because if the court grants the parties shared parental responsibility but requires a designation of the school boundary in a parenting plan after the parties are divorced, this could in turn cause some conflict. Next, let's get into some of the more common school placement disputes, and let's start off with the most classic one of them all, and that is the never-ending debate of private school versus public school. There's some parents who may prefer private schooling because they tend to be smaller and have a better student-teacher ratio, and maybe they have a more vast opportunity for either extracurricular activities or certain enrichment classes or specialties. Whereas other parents may think that public school is the way to go, especially some of these public schools in the more affluent districts. They can oftentimes offer equal to or even more enhanced opportunities than private schools. There may be some religious differences between the parties. Let's say one of the parents wants the children to go to a religious school and the other parent wants them to stay in the public school system. The difference in cost and philosophy may always breed a dispute between the parties or the parents after they get divorced. Right next to that particular debate is changing schools versus stability. This comes up when the school has, for instance, a K through 12 program. There are different grades in which the children may be able to transition to different schools, like when they enter middle school or when they enter high school. Some parents are going to argue that stability is the key. The children must stay with their same friends and their same teacher and their same same teammates, while the other parent may be advocating for either a change. Another big one is when one of the parents relocates. If the parents live in different school districts or in different cities, trying to determine where the children will attend school will cause a big conflict and oftentimes will be dealt with by the court. Another reason for school placement disputes is a little bit controversial, and that is when the spouses after divorce get involved in a different relationship. If they start to cohabitate with somebody else who in turn has children, and therefore there's a blended family, well, maybe those children are going to a particular school and the parent now wants to have all their children attend the same school as their new significant other. And the final reason for some of the school placement conflict, which at least we'll cover in this video, is whenever the children or one of the children has special needs. If the children have special needs and the school that they're currently at does not have the proper accommodations or resources to address those special needs, then both parents may have a different view as to what to do. One of the parents may want to stay in that school, the other parent may want to change to a different school, and if both parents decide that they want to change schools, oftentimes they are not on the same page as to what school to change to, and the emotions can be heightened because remember, we're dealing with children that have special needs and that can cause additional conflict. I must mention that as a practitioner, if anyone ever approaches me to try to get assistance with a school placement issue, the first thing that I always do is I look at the parenting plan or the custody agreement. The language that is in these documents usually governs. What do I mean by that? Well, if the parenting plan or custody agreement says that the minor children will attend this particular school through 5th grade or through junior high or through high school, well, that document will govern, and that is where the children will most likely remain in school. Also, as a practice tip, remember that in school placement motions, the best interest of the children is paramount. This is what the courts will always look at. In my experiences, it has been really hard to overcome stability. So if the children have been in the same school for the last several years and all of a sudden one parent wants to decide to yank them out of that school, it is going to be a very difficult mountain to climb to try to prove that moving this child after all this stability is in their best interest. So now we'll give a couple examples of when the current school placement for the children may not necessarily be in their best interest, or one of the parents who wants to change the children may have a shot at trying to get the children changed. The first situation is, let's say that the parenting plan designates that the school should be in the father's boundary and the minor children in that case are registered in a school that is not in the father's boundary. This happens a lot. People move, or maybe they don't like the school that's in their particular boundary, and I'm not trying to accuse anyone of being fraudulent, but sometimes they may use a different address so that they can get into a school that's a little bit better, or maybe there are schools that will allow enrollment from different boundaries if they're not at full capacity. So the first way to try to attack a school placement is when the children are not in the boundary that is designated in the parenting plan. Well, at that point, if you go to court, you may have a chance because the children are no longer in the appropriate boundary. Also, there may be a situation in which the children or the child has a specialized skill or requires specialized training. For example, many of you know I am a theater dad. My son was involved in musical theater from a little boy all the way through high school, where he attended a performing arts high school. Those high schools oftentimes are called magnet high schools, in which they have a specialization, and he was allowed to attend that school despite not living in that particular district. In cases in which children need specialized training, these specialized schools oftentimes have open boundaries. So if the child has a special skill, then that parent may have an opportunity to move the child out of their current school designation. The final example of how a parent can possibly move a child from their current schooling is when the school that the child is currently enrolled in is no longer in the best interest of that child or the children. What do I mean by this? Well, it is very fact specific. It could be, for instance, a safety issue, or maybe the school did not perform up to the standards it needed to and it dropped down in terms of its overall ranking, or maybe there was a turnover in the administration, or maybe they closed some of the certain programs. So this is very fact specific, and it has to be a very compelling argument that the current school is no longer in the children's best interest. Also, another practice tip: before jumping into litigation on the school placement issue, it behooves both parents to try to confer and try to work this issue out. Litigation is very expensive and very stressful, and you're going to have to subpoena people to court who are going to be very uncomfortable testifying in front of you or your former spouse. When the parents can't reach an agreement, they have to lawyer up, and it could take a day of court, and as we all know, there'll be a court reporter and there'll be evidence, and it could get very complicated. So keep in mind that courts always prefer when the parents can come together despite their differences and maybe attend mediation or counseling or family therapy and try to work out the issue. If conferring with the other parent does not work and now litigation is necessary for school placement, the key factor that the courts will always consider is the children's best interest. And I have to say this again, stability is a huge key. Courts rarely like to all of a sudden remove children from a school that they have been accustomed to or have been in. It doesn't mean that it won't happen. It means that there has to be a compelling argument, and it must be in the best interest of the children to move them to a different school. So when litigating school placement motions, it is important to gather as much evidence as possible to support the argument that this school that that particular parent wants the children to attend is in their best interest. Keep in mind that Florida allows for guidance as to what is in the children's best interest in this arena, and it appears under Florida Statute 61.13. Some of the factors under the 61.13 analysis is the anticipated division of parental responsibilities after the litigation, including the extent to which parental responsibility will be delegated to third parties. The court will be looking if the parents will be the ones that are taking care of the children and bringing them to school back and forth and attending parent-teacher conferences, not grandma and not uncles or cousins. So that is an important one. Another one is the length of time the child has lived in a stable, satisfactory environment and the desirability of maintaining continuity. Again, I cannot say it enough. Stability is key. Another factor that courts here in Florida will consider is the demonstrated knowledge, capacity, and disposition of each parent to be informed of the circumstances of the minor child, including but not limited to the child's friends, teachers, medical care providers, daily activities, and favorite things. Finally, the other relevant statute in Florida is the demonstrated capacity and disposition of each parent to participate and be involved in child's school and extracurricular activities. It will be very hard for a parent to come in and say, oh, I want to change schools because the school is bad, and that parent has never stepped 1 foot into that child or those children's school. Not a good look, not a good strategy. Remember that it is also important to document concerns prior to the litigation, because if someone ends up having to go to court, documentation like emails and text messages from both the other parent as well as the school officials can provide great evidence as to why that school is not in the children's best interest or why another school may be a better choice. Also, if the child has a unique area of interest, messages relating to that training and why it is that the child needs this enrichment or the specialized training is also important. Or on the opposite end of the spectrum, if the child is receiving bad grades, those report cards will be very important pieces of evidence at a subsequent hearing. Additionally, if there's any concerns as to safety, like bullying, or if there was some sort of event at the school, having documentation of that is very important. Another important piece of the evidentiary puzzle is Google Maps. That's right. In preparation for a hearing on school placement, it is important to physically print out the Google Map distances between the residence of both parents to the current school, and the same thing for the addresses of the parents and the new school and what the parents have to do to travel. If travel becomes burdensome for one of the parents, then that will indicate that there may have to be additional information about busing or private transportation. Remember also, as a practice tip, that the parties can request for the court to take judicial notice of these Google Map printouts under 90.2035 of the Florida evidence statute. That particular statute allows the court to consider the Google Map printouts, and that is something that should be considered in terms of filing before a hearing on school placement. As we had briefly mentioned, information about school grades as well as the profiles of the school. In other words, in Florida, they have A-rated schools, B-rated schools, and so on and so forth. It is important for information about where the school is ranked, what their school grade is, and any profiles and accolades that the school may receive. The parties need to realize that when they go to court, they will be expected to testify. They may have to give a direct examination. They may have to get cross-examined by somebody, whether it's the other party or their attorney, and they need to be able to articulate to the court why their school of choice is in the best interest of the children. So they need to steel up and get ready, because the other party is going to be coming at them. Another strategic consideration is sending a subpoena to a school official, whether it be a principal or an assistant principal, maybe a guidance counselor, or the teacher of the child in question. Now, everyone must tread carefully, because oftentimes these school officials are very uncomfortable in attending court and having to be put in the middle of these proceedings. They oftentimes may have counsel or lawyers representing them from the school district who will reach out to the parties or to the attorneys of record if the parties don't have attorneys, and oftentimes voice their objection to the school official attending a hearing. So this is a very important consideration, but it is a delicate balancing act, because courts oftentimes will give some credence to what these school officials say. Because remember, in a hearing like this, one of the parents is going to go in there and they're going to scream and testify that the school is a horrible placement for the children, and then the other parent's going to say, oh, this school is the best school ever. So there's always going to be that conflict, whereas the teacher or the school administrator, they're going to come in and they may be seen by the court to be a little bit less biased. They will provide very relevant information to the task at hand. Why then is it so important to consider having these school officials show up at court? Well, they're going to pump up the school that they represent. They're not going to come in there and say, oh, our school sucks. No, they're going to come with pamphlets. They're going to come with school grades for the children. They'll talk about tutoring and enrichment and any type of transportation. That live school official is going to be 10 times better than coming to court with a pamphlet and being like, here, judge, here's the pamphlet of why the school is so great. Maybe don't consider doing it. I mean, if you can't secure a school official, well, and that's the only thing you have, it's the best you can do, well, it's the best that you can do. But a school official is going to enlighten the court as to what's really going on. They will also be able to speak directly to the court if the child is enrolled in that school as to how the child is doing. They will oftentimes speak to the different teachers involved that have that child in their class and tell the court with no BS how that child is doing. But again, before we get off the school officials, tread carefully. Furthermore, the last group of witnesses that may come to testify are going to be some expert witnesses. In some cases, bringing an expert to testify is important, like a child psychologist, an educational consultant, or someone that has specialized training in the particular field or specialty that that child is trying to get into. These professionals can provide the court with an objective opinion as to what the child's needs are. All right, so before we sign off, I want to leave all of you with some final thoughts on the issue of school placement. It is imperative that if school placement becomes an issue that has to be litigated, the parties who are litigating it must present a comprehensive argument. This means preparing a thorough argument that addresses both the academic as well as the practical aspects of school placement. This includes contemplating the child's academic history, how long they have been in a stable or current school, transportation, logistics, as well as the emotional well-being of the child. School placement can be one of the most emotionally charged and complex issues litigated in a divorce case. Why do I say that? Well, if the parties can't confer and agree to school placement, which is always the best case, but if they can't, then the court is going to hold a hearing. It will consider all of the relevant evidence and testimony of the parties, and it will make a choice. And when the court makes that choice, one of the parents is going to be really happy, but the other parent is going to be devastated. So it's important that both parents approach this issue with the children's best interest at heart, while also having the tools and understanding on how to litigate these cases in the event that that becomes necessary. All right, so that is a wrap on the issue of school placement. If you know anyone that may find this information useful, have them look us up at www.segarralawfirm.com. We have offices in Miami and Orlando, Florida. Se habla español. Please do us a favor, like this video, subscribe to the Divorce Broadcast, and we will see you all soon. Thank you.